This video breaks down a series of brief real courtroom hearings from Washington State, including a protection order service issue, a motion to modify a no contact order, and a procedural reset. These matters were handled quickly and focused on legal process rather than testimony. This narration is for educational purposes only and does not offer legal advice. If you want clear summaries of real court hearings like this, subscribe now for continued courtroom coverage.
Emily Turberville.
I'm here.
There I see you on Zoom call there, ma'am. And so I can see that looks like Mr. Franzak still hasn't been served. Were you able to get service on him?
One of the Olympia police people, they gave me a FaceTime and was asking me if this was his apartment building, but I never got any call back for it.
So I think looks like you've been here a couple of times already.
Yep.
And so at least once, and then 2 weeks ago, we reissued the temporary. I still don't see any service. So pretty much all that can happen today, is if you still want to pursue this, we'll have to try this one more time.
That is so outrageous because literally I was on the phone with a cop and he was like, "Is this his apartment?" And I was like, "That is his apartment." And he's like, "Oh, I'll contact you in a week and tell you if we handed it to him or not." And I'm like, "Why can't you just hand it to him now? Because you're at his apartment." And then they just hung up.
So ma'am, I don't know what went on out there with the police officer and the person. All I know is I can't proceed without proof of service. I can't.
Okay,
and so,
then we could just, sorry for cutting you off.
That's all right. Go ahead.
We can just reissue it then.
And then you can follow up with the what law enforcement agency is this? Is this the sheriff's office or the 22nd? So your next court date is going to be December 22nd.
Okay, let me see if I have court on that date because I have 3 other court dates coming up. Nope. Alrighty. What is it? December 22nd?
At 9 a.m.
Okay. Alrighty. Thank you so much.
You're welcome. The copy of this will get sent to you. Good luck.
Thank you. Bye.
So in this case, an order was previously entered by a different judge. That order remains in place. This comes before the calendar on Ms. Hunt's request to modify the existing order. And then Mr. Stonecipher filed a declaration in response to your request. Did you see that?
No, I was originally going to ask for a continuance because by my servicing company, he was never served. So I'm surprised to see him here today, but happy to take care of the hearing. Okay. So I did not know that he was served.
Well, yeah, he got served. We got the packet last week. Or no, wait a minute. Hang on just a minute.
If I may, Your Honor, I was never formally served. I received Mrs. Hunt's.
Hang on, we can hear
from,
of course. You're here with an attorney, so I'll
correct. Okay.
Mr. Clark, if you want to address that, you can.
Yeah, so he was not formal. Yeah, as he was saying, he was not formally served, but he did learn about this through other means. And Ms. Hunt should have received the declaration. I emailed it to her and I mailed it to her with substantial time for her to receive it.
Did you not receive that, ma'am?
I never received those documents.
So what I think it's only just a one document. It's a declaration in response. Give me just a minute. Can you print that? What we're going to do, ma'am, we're going to print off a copy of that declaration. I'm going to have you review it. Then you can go back into the court. You can review it. And then if everybody's agreed, we'll just go forward on this motion here today. So no one has to come back.
Okay. Thank you, Your Honor.
You're welcome. Bradbury, can you come back on the Zoom call, please?
Yes, Your Honor.
Hi there. So I've reviewed your petition, a number of Ring doorbell videos that I've used, which I reviewed all those. A temporary order was entered, and then today's supposed to be the hearing to determine whether or not a full order will be entered. Given that he's not here, it's now coming up on 9/20, enter a default order in your favor. But I have a couple of questions first, frankly. I mean, I thought I read somewhere that you've moved into a different apartment while this is pending, or are you back home, or what exactly?
So the complex was kind enough to move me into a new unit as this was going on, so I didn't have to be door to door with them since we're neighbors. But since this situation has happened, I am moving out, and I am moving today, actually.
Okay. And so are you moving into a different establishment or?
It will just be a different unit, like across the way, like farthest I can get away from him.
Okay. And then how have things gone since he's been served? Have there had any issues or problems or?
Yes, the day after he was served, he tried to make contact again and enter my house.
Okay, and I thought that was the video of that, was it not? Was that?
Yes.
Okay, all right. How far is the new apartment away from him? Because here's why I'm asking these questions, because the temporary order I noticed, you know, we see no contact orders or anti-harassment orders fairly, you know, this isn't a neighborhood, you're in the same apartment complex, but, you know, we can't really put distance restrictions on them because we can't enter an order that prevents someone from getting to and from their own home. And the distance restriction in the temporary order, which was entered by a different judge, said don't come within 1,000 feet, which isn't really practical given where he live and you live, but I will put a distance based on everything you've told me. I'm going to enter, I'll enter an order that will be in place for a year. We can do a distance restriction, but I want to reduce it to this amount where he can get to and from his establishment violating the order. See what I mean? So how far away from, I mean, it's 500 feet, 300 feet, what exactly?
It could honestly even go up to the 1,000 feet with where I'm moving. We're complete opposite ends of the complex now.
All right. Give me just a minute there, ma'am. So then an order will be entered. It will be in place for 1 year, go through December 8, 2026. And then the parameters of the order will mirror what's in the temporary order. He's not to cause you any harm, not to contact you, don't engage in stalking behavior, don't come within 1,000 feet of you. And I think those were the two provisions of the order. So the order will be exactly the same as the order here.
Thank you, Your Honor.
And then since he was served and it mirrors what's on the temporary, he won't need to be served with this. And if you want a copy, do we email a copy or do they? You can get a copy of that off the district court website, ma'am.
Thank you, Your Honor.
Good luck.
Thank you. Have a good one.
So you have asked to adjust the no contact order in the response that was filed by from Mr. Stonepfeifer. Well, I guess having said that, are you prepared to proceed here today? You said earlier that you were.
Yes, Your Honor.
Okay. There's nothing in this order that prevents you from participating in any sort of investigation, which I think kind of came as news to Mr. Stonepfeifer, if I understand that. But I'll hear from you briefly as to why you think the no contact order should be adjusted.
Do I need to stand, Your Honor?
You do not.
Okay. So in seeking out legal counsel, I have been directed that I should not talk to CPS or the police or the school district about the allegations that my son has told me concerning 3 educators at the preschool that inappropriately touched him, which he is now receiving trauma therapy for. The legal counsel that I received said that that could be viewed as third-party contact and that I need to go before the court and request that it be modified.
So I'm going to stop you for a second and tell you,
Okay.
I don't view that as third-party contact. Third-party contact is going to them and say, hey, go tell this person this or that. If
Okay.
you're reporting something, I don't think that there's anything in this order that prevents you from doing that.
Okay.
I know that, excuse me, I know that Mr. Stonepfeifer disagrees with that, but Mr. Clark, I'll to you, what's your on what I just said?
No, I agree, Your Honor. Mr. Stonepfeifer doesn't have any intention to stand in the way between Ms. Hunt and any kind of investigative organizations, yes, in particular. He would like this case, this motion decided on a very narrow basis. And then 7.105.500 paragraph 3, where in order to have a modification or termination of a protective order, the moving party needs to show a substantial change in circumstances such that the respondent will not resume engage in or to engage in case acts of unlawful harassment. So none of the allegations presented in this motion would give any indication that Miss would not resume harassing my client. And for that reason, we just like this denied, and Miss Hunt can, son's interests in proper forum. Further, we'd like for attorney fees because they're allowed under the statute. And we're also interested in moving to seal the record because of these inflammatory statements that Ms. Hunt is making about Mr. Stonecipher, including asserting that she just asserted in court that he has done these things, that he and two accomplices have indeed sexually abused her child. These are horrific and inflammatory allegations, and they should not be out there in a public record. My client is a teacher and he works with young students. However, he hasn't had any interaction with Ms. Hunt's students June of 2023. It's not to say that, time bar to the allegations that she's bringing forward, but it's just that these just seem kind of and a lot of hearsay in her submissions. Thank you.
So ma'am, I'll give you the final word here.
Yes. So son started sexually
Okay,
acting.
so ma'am, and I don't want, the issue here
Okay.
is whether or not this order needs to be adjusted. And remember, he's the
Okay.
petitioner, you're the respondent in that order. And so with regard to, your
Okay.
reference in yours and was just referenced by Mr. Clark, that's going to be heard by and decided by somebody else, not me.
Okay.
And so the only issue here is whether or not this order be changed.
Okay. So I've been counseled that anyone that I talk to that could then take my information and communicate it to Mr. Stonecipher, that could be considered third-party contact.
Okay.
And I'm trying to avoid being in violation of the protection order or prosecuted for participating in a full investigation, me and my son being able to be involved.
Okay, well, I don't, I don't think there's anything in this order that prevents you from participating in any sort of investigation or thing like that. I'm not sure what you were told, but based on what you have said and what you have put in your paperwork that was filed, I don't see that there's any reason to adjust the no contact order at this time, remain in place.
Okay.
So your request to adjust the no contact order will be denied.
Okay.
To Mr. Clark's comments about sealing the record, I don't think that I'm going to need a formal motion on that because typically we don't do that. And so if you want that, you're going to have to bring a motion on that with a brief as to how we can do that because people file, stuff in these sorts of hearings and we just don't, absent compelling circumstances, we don't seal records and so, or court files. So you're going to have to, again, if you wish to do that, Mr. Clark, on behalf of Mr. Stonecipher, you'll have to, brief that. And I'm also given, I'm at the point, I'm going to deny the request for attorney's fees.
Under what basis, Your Honor?
What do you mean?
Did you make any findings that would support that ruling, denying attorney fees at this time?
I think it's just, I think it's discretionary and I'm not to do it.
Okay, thank you.
Sure. You're free to go, ma'am. No contact order remained in place. And Mr. Clark and Mr. Stonecipher, you're free to go also.
Your Honor, one more question. Does still need to be served the paperwork? My understanding is he needs served the paperwork
What's that? No,
that I originally filed.
We've handled the handled it here today. So this hearing is over. The no contact order remains in place.
Okay.
You may go.
These short hearings highlight how courts handle procedural issues like service delays, the limits of protection orders, and requests to modify or seal records. While the cases were brief, each ruling carried real consequences for the parties involved. This channel aims to explain courtroom process, not to take sides or speculate. Thanks for watching and for engaging thoughtfully with real legal proceedings.